healer in you, the king, the queen, the magician, the lover in you. Every single day, we are called to walk in our purpose. Answer the call. Lay down your burden and anything that holds you back and take your rightful place. The battle is everywhere. It's right in your face. Let's go.
Welcome to magnets, crystals, and pyramids. Success is your destiny. Love, wisdom, power. Remember always who you are. Yes, yes, I am. Love, wisdom, power. Yes, yes, I am. Love, yes, power. Yes, I am. Yes, I am. Love, wisdom, power. Yes, yes, I am. Wisdom, power. Master. Yes, I am. Yes, love, wisdom, power. Yes, I am. Say to yourself, yes, I am. Yes, I am. Master. Welcome to being incarnated on planet Earth. You are now gifted with the supernatural abilities. Welcome to magnets, crystals, and pyramids. Success is your destiny. Love, wisdom, power. Remember always who you are. Yes, yes, I am. Love, wisdom, power. Yes, yes, I am. Love, yes, power. Yes, I am. Yes, I am. Love, wisdom, power. Yes, yes, I am. Wisdom, power. Master. Yes, I am. Yes, love, wisdom, power. Yes, I am. Say to yourself, yes, I am. Yes, I am. Yes, I am Brahma, Master, Vishnu, Shiva. Yes, I am Adonai. I am Elohim. I am Allah. I am Ra. I am Anu. I am Tengri. I am Ahura Mazda. I am Yahweh. I am Buddha. I am Krishna. I am Jehovah. I am Quetzalcoatl. I am Tahuti. I am Wakantanka. I am El Shaddai. I am Shekinah. I am Lord and the Master. Yes. Arm, leg, arm, head. Greetings, welcome to Moorish Monday. Presently waiting for Abdullah Bey to come on. If you'd like, you can go ahead and start because Abdullah is not in the queue. So you may proceed with the show until he arrives, and I'll bring him on the platform. If you can hear me. Can you hear me? Well, I don't know if he can hear me.
Can you hear me? Yeah, I can hear you.
All right, Abdullah Bey is running late.
Yeah.
So you go ahead. Oh, wait, here he comes.
Peace, everyone. Welcome to Moorish Monday with Abdullah El Bey. Welcome, everyone. Yes, we have part two of due process, a key to freedom. Part two with Keng El Bey, and I'm going to I'll turn it over to brother Israel, brother, and then we'll hear from brother Keng El Bey.
All right. So peace. It's the Moorish Investigative and Research Committee Educational Lessons on the Moroccan Post Media YouTube page. Free recorded class lessons. Moroccan Post School of Government and International Law by Terrence Bey, Shem Malachi Bey, and Abdullah El Talib Mosey Bey. Moorish Union of Sovereign Tribes by Keng El Bey. Session 1, the basics of criminal investigation, the meaning of evidence, finding of facts, and conclusion of law. Session 2, introduction to the application of law and evidentiary standards, part 1. Session 3, introduction to the application of law and evidentiary standards, part 2. Session 4, using legal principles to draft motions and pleadings, part 1. Session 5, jurisprudence/philosophy of law and legal principles as the foundation to run government and to handle legal cases. Session 6, using legal principles to draft motions and pleadings, part 2. Session 7, the use of affidavits, notary processes, and notary presentments. Trust and contractual legal safeguards. This is a 12-week course which provides an in-depth exploration of trust, contracts, and the legal mechanisms that safeguard them. So our course, Master Trust Functions, discover the role of Master Trust Functions, discover the role of a trust protector, intellectual property law, demystify assigners and assignees, understand power of attorney, navigate licensing, leasing, and renting, strengthening your contracts. This duration is a 12-week course. The starting date is Saturday, March 8th, 2025. At 2 p.m. is going to be from 2 p.m. to 5 p.m. Eastern Standard Time. Format 100% online with live question and answers sessions. The tuition, $299 notes and 99 cents. Register now. For more information, you can call Brother Abdullah Bey, 215-300-5471. And his email, etymologyvocabulary@gmail.com. All right, this is a book by Brother Keng El Bey and Brother Abdullah El Talib Mosey Bey called Legal Principles, the DNA of the Legal System. All right. So today's presentation is Understanding Due Process, the Key to Freedom, Part 2. Today, so we're going to be covering substantive due process. Substantive due process, a legal principle, essentially meaning that the government cannot deprive a person of life, liberty, or property without a sufficient compelling reason, meaning the law itself must be fair and not infringe on fundamental rights, considered deeply rooted in American history and tradition. Key elements include identifying fundamental rights, demonstrating a substantial government interest to infringe on that right, and applying the appropriate level of judicial scrutiny. So how does substantive due process function? Substantive due process looks at the specific wording in the Constitution and statutes to see if it infringes on fundamental rights.
So when we talk about substantive language, you got to look at what it expressed. What was the forefathers expressing this is a historical document. So you must go back to the history, right, to understand the philosophy and the thought process that went in constructing this instrument. You got to go to the original source of what it's come from, right? Those who helped draft it and their interpretation of what it means. So you got to go through historical text. When we're looking at the Constitution, you just can't just look at the contextual. You got to look at the historical elements of this. And you look at other findings of facts to determine the true original interpretation. Because sometimes through the transliteration of this document, people then redefine what the Constitution was a constitutional violation. They didn't meet constitutional muster, so now there's a conflict, right? So we got to understand the legal principles associated with it, right? What are some of the legal principles? The rule of law, right? Why is that very important to understand the rule of law? Because the rule of law is like a light beacon, right? When a sailor is trying to find his way to shore, they have a lighthouse. The rule of law acts as a lighthouse to guide those into shore, to ensure the integrity of the process. Without understanding these rules, because it's called the rule of law, it's not a process, it's a rule. That means that this rule is etched, is in stone, and is set at the foundation of a constitutionality of this construction of this instrument. And you have to understand this rule of law. Then we're going to break it down what the rule of law birthed. It birthed due process. All of these things came out of equity. Equity was the foundation in which then created through understanding in its philosophy on how to look at law. So now you can understand the philosophy that goes with the principle so that you can understand the true interpretation so that you can always hit your mark. When we're talking about understanding law, you can't get too far away from that. There's a lot of people teaching processes. Processes is a very limited way of dealing with law. It's very limited. So a lot of guys and females a lot of men and women in our community look at different processes as a way to deal with law. And sometimes they get lucky, depending on the court, depending on who can handle it. You got to understand when a judge is very experienced or a judge who's not experienced or an attorney who is not as experienced may not be able to handle some of the stuff that you may be presenting. But when you run across a well-experienced judge and a well-experienced attorney, then a lot of these processes get challenged. And then they get what? They get ripped apart because they can't hold and have standing because the people who are using these processes don't understand how law works in totality. So when you know law, you know how to look at law, and you know now you can see errors, mistakes, omissions, defects, right? Now you can see where it's flawed. You can look and you can tell by understanding did the court get it right. Because if you know how the law works and operates, that's why I talk about operation of law, application of law, right? Principles of law, right? The rule of law, findings of facts, and conclusion. Why do I talk about principles? Each principle has its own set of fingerprints, like your hand, right? Right? Yeah. Jeremiah, go in the room, please. So, when we think about principles, I want you to think about when you say elements and you think about principles. Hold on one second.
All right, this is very good. King is giving us the foundational teachings on law. So we're looking at the different methods of teaching law, where he was talking about the teaching the foundational of law, teaching the philosophy of law versus the processes. And so it's just looking at whereby teaching from a process approach is very limited. You will give one a very limited understanding of law, whereas teaching from a foundational jurisprudence approach will give one a foundational understanding of law. So this is something that Ken and I have talked about over the past 8 months, and we had a discussion this morning. I wanted him to reiterate this point, and that's something we'll continue to do. Often times where this approach dealing with the philosophy of law is not taught to us in this Moorish movement, whereby those who are will introduce to someone who's what they call teaching law, they'll come from a process approach, which is will give one a very limited understanding of law. So I'm glad that I wanted him to reiterate. Israel, you have a comment to make on that? Something you want to add to that? No? All right.
Yeah.
So we're just waiting for King to come back. So this is so we're looking at here due process, the key to freedom, and knowing that there is an article that I came across about 3 or 4 years ago called the history of equity jurisprudence. And this is where King was saying that it's all equity, that equity gives birth to the rule of law, and the rule of law gives birth to due process. In the article, the history of equity, you can Google this, the history of equity jurisprudence. In the first 3 or 4 pages, the author gives the foundation of equity, going back to the Code of Hammurabi. And then as the article goes on, and how the concept of equity was watered down through Greece and Rome. And then and I was just talking to Israel today, dealing with what they've done was and in my teachings of semantics, of how words acquire new meanings, the 3 classification in which words acquire new meaning. generalization, specification, and transfer meaning. So equity has been given a constructive meaning, what's it called, a specified meaning to court of chancery. So so where equity, where it's all equity, it's all equity, and so they have limited using the specification approach of limiting or restricting or specifying or limiting the meaning of equity to refer to that of chancery court, whereas equity having a much broader meaning where it's all encompassing of dealing with equality. It's all encompassing, but it actually restricted her meaning. So it's all equity. So the rule of law embodied in the principles of the rule of law is equity. Due printed. It's actually equity is embodied in all of the legal principles. But once again, as the Europeans have restricted or limited its sense. And so this is where I just wanted to offer that to you. Once again, that article is entitled "The History of Equity Jurisprudence." The history of equity jurisprudence, but it doesn't go through the as I said, as I have given the classification in which words acquire new meanings, transfer meaning, specification, and generalization. So here we're looking at one of the types of equity, substantive. You have procedural, due process, procedural due process, and substantive due process. So we have King is back.
So, for example, right, when we talk about you have an unlimited right to contract, government cannot, when we talk about your substantive language, they cannot try to stop your language in your contract. You have a right to write a contract in specificity in accordance to your understanding and how the agreement could be met. If I want to pay you in gold and silver or sheep or cattle, government cannot say I can't do that. That's restraining a personal right. A substantive right that you have is an inherent right for you to contract and limit it. Now they can stop you, like if you want to sell cocaine, crack or marijuana, because you're using Federal Reserve notes, right? And it's already outlawed, right, for you to use those Federal Reserve notes in such a way that you're selling drugs, illegal drugs. So it's already legislated. So when you start doing things against government, you're affecting government personal rights because they have a contract with the Federal Reserve, right? They have a contractual obligation, right? So you can't just say, I'm going to interfere with the government's business. You're obstructing official business. You are affecting how government is dealing with a private institution and with how they're going about doing business. So they created what? Penal codes to penalize those who infringe upon personal rights because there's a contract. But in the same context, government can't do that to you from one private individual to another. They don't have the realm to reach in there to say, I'm going to restrict your language in your contract and bar you from doing such actions when it doesn't affect government in any way. So now, if government encroach upon a personal right that is not inherited within government, then government then encumbered or encroached a right that they didn't have, and they went into your personal rights, affecting a jurisdiction that they didn't have the authorization to do. So we have to look at the substantive language and statutes, right, to see if they meet constitutional muster to ensure the integrity that if the statute violates a right, a personal right, then the statute is void ab initio on its face because from its inception it violated a right that it said it was guaranteed to protect. So there's a conflict, right? In law, they call it a conflict. So you can challenge a statute based on that, right? So you got to know these principles in order to do these things. If you don't know these principles, right, then you don't know what it is. So, for example, what are the 5 elements in the rule of law? It's accessibility, fairness, right? No arbitrariness, right? Um,
Accountability,
Accountability, and there's one more, Abdullah. I'm trying to remember.
equality before the law.
Equality before the law.
E-
So, so so when you look at the rule of law, those are the 5 elements that have to be there, right? Those are the fingerprints of the rule of law. If you don't see that in your case, then you already know they didn't abide by the rule of law. Then we got to look at the context of due process and the other elements of due process: a right to be heard, a right to confront your accusers, a right to inspect the evidence, a right to present evidence, to present witness, a right to remain silent. All of these different things are constitutional rights, or these are not constitutional rights, these are constitutional protected rights. There's a difference. The Constitution is not giving rights. It understands there are inherent rights that it's supposed to protect. So when you understand this foundational work, we can now move into the international form to see how the law is supposed to operate in the international form jurisdiction. So it's very important to learn this, right? Learn this foundational so that you can win. People say, King El Bey, how do you keep winning cases? Because I understand law and how it operates. I'm not closing my eyes and saying, let's get lucky. Come on, lucky 7. That ain't what I'm doing. What I'm doing is I'm analyzing, I'm looking at the language in the statute, I'm looking at everything and I'm breaking it down. And I'm using the principles as the guiding light to steer me home to shore. And now I know, okay, based on these facts, these elements, the government violated due process. So if they violate due process, you can't break the law to enforce it. You have no case. And most attorneys only know procedures. They're not jurists.
What we go to the next slide, King, or this is we
Yeah,
good?
we can go next side.
All right. Substantive due process. Identification of fundamental rights. Fundamental rights are enshrined in the Constitution and protect individuals from arbitrary state action, ensuring basic human dignity and participation in society. When government's actions substantially interfere with fundamental rights. While due process often refers to procedural fairness, substantive due process goes further by protecting certain fundamental rights not explicitly listed in the Constitution, such as the right to privacy or the right to marry. Judicial reviews. Depending on the complexity of the rule, a formal hearing may be held where individuals can present oral arguments and evidence related to the proposed rule. Controversial applications. The agency must consider all relevant evidence presented during the comment period and hearing process when making a decision.
Now, there, like you got, all right, King.
So, most of the times when you're dealing with agencies, they're looking at the procedures. They're looking at, did they follow the administrative procedures? Most of them don't understand the Constitution itself because a lot of attorneys don't understand that instrument in its entirety because they're not jurists. So they don't know the historical context of that and other foundational and philosophies of law that went into the construction of the rule of law and all of these other principles. So what they adhere to is strictly to process, what I mean by procedure. So they want to be procedurally correct. But in order to be procedurally correct, you still have to understand these other fundamental principles. And without understanding this foundation, you can't be procedurally correct. So the average human, right, who are not jurists, they can't see with the blind eye. You see what I'm saying? So they only know what the government is presenting. They don't know how to challenge to see if the statute even is constitutional. They don't even look at the language in the statute to determine if they met all the elements in the statute. So when I look at law, right, I'm looking for the facts, but I'm trying to unravel, did they adhere to due process? Do the state know what due process even really mean? Did they follow the rule of law to ensure the integrity of the process? So now I can challenge things. I can look for discovery issues. I can look at, under the Sixth Amendment, I can ask a constitutional question, right, under the Sixth Amendment. So what is the Sixth Amendment? It deals with discovery. Also Brady, right? So you have what they call Brady versus Arizona. That was Brady discovery. But what I need you to understand, there's a case called Crenshaw versus the United States, dealing with the nature separated from the cause. There are two different elements. In the substantive language, understanding the historical text of that Sixth Amendment. What is the nature? So the Constitution only presents four jurisdictions. That's common law, there's equity, admiralty, and maritime. So they got to identify out of the aspects of those jurisdictions, which one are they dealing with? What are they coming under? What is they constitutionally sound? Because they also have to be constitutionally sound as well as procedurally sound. Are they constitutionally sound? Did you have, when you asked for discovery under Crenshaw, right, to identify the nature separated from the cause, right? We ain't even talking about conclusion of the findings of facts separated from the conclusion of law. I'm just asking under the Sixth Amendment application to identify the nature. What is the nature of this? and separate it from the cause. Because they'll read you and identify the cause of action without giving you the nature. What is the nature of this event? They'll say, well, it's civil or criminal. Okay. Under what aspect of what constitutional aspect are you using? Identify the constitutional jurisdiction because it only identified 4. Which one are you using? Most attorneys don't even know.
Give those 4 again. We have admiralty, maritime, equity, and
Common law.
common law.
So the United States, right, is a mixed jurisdiction. It's a civil law and common law system. That's why all actions are what? Civil actions, but they don't tell you which civil action is it falling under. And you have a right to know because there are categories of law under each aspect of that jurisdiction. So you have to look at, so if you say if we fall under common law, now we got to look at common law cases, right? If it falls under equity, we got to look at equitable cases based on court cases, right? Equity. Now we got to, if it falls under admiralty or maritime, we have to look at that and see what aspect of what they're using, right? And show how it's being identified constitutionally. Because the Constitution said that Congress only can make courts inferior to the Supreme Court. What does that mean? If they're inferior to the Supreme Court. I want y'all to understand that. I want you to take some time and ask yourself, what do they mean by inferior? What is the historical meaning as it relates to the Constitution, as it relates to it being inferior, right? This is why the Supreme Court is the Supreme Court. Why is it supreme? Why do I have why is it supreme over this, right? So now we got to look at the condition that is set up. Okay, go ahead, Abdul.
Yes. So one of the legal principles that dealing with and then looking at the United States Constitution, one of the legal principles is the separation of power. So separation of power, when you're looking within that Constitution, is so this is where King is coming from, and this is what he's asking for us to think about. Is the separation of power, and if in Article, if you look at the Article 1, Section 1, Article 2, Section 1, Article 3, Section 1 of the United States Constitution, Article 1, Section 1, the United States that deals with vested power. You have the word vested. So legislative power shall be vested in the in Congress, consisting of the House of Representatives and the Senate. So we have the word vested. So that's inherit. You have vested, V-E-S-T, and you have invested. Vested means inherited. Invested means delegated by the power invested in me by the Commonwealth of Pennsylvania. I now declare you man and wife. The power invested doesn't say vested, because it won't be vested in me. It wouldn't be. It's vested. So you have vested power that's inherited. Article 2, Section 1 dealing with the executive power. Executive power shall be vested in the office of the President of the United States of America. You have Article 3, Section 1. Judicial power shall be vested in the Supreme Court, United States. So one Supreme Court. So let's stay with Article 1, Article 3, Section 1. Article 3, Section 1. So the inferior courts are legislative courts, or inferior courts are created by Congress. But when you're talking about the Supreme Court, the Supreme Court is drafted within the Constitution and it has vested power. The inferior courts do not have vested. The superior courts do not have vested judicial power. The word vested, be inherited. So the inferior courts do not have inherited judicial power. So that word vested, V-E-S-T-E, language is key. The word vested. All right.
So that was beautiful, my dude. That was beautiful. Wait a minute. Deontay letter. It's on 15%. I call you. So what everyone needs to understand, that word vested. We talk about inherent right. So they also say that Congress have plenary power, right, over its jurisdiction. It has complete control over its legislative work, right? So you got to understand. So when we look at statutes and we look at those are creatures of Congress. When we look at United States codes, those are creatures of Congress. And Congress is a constitutional creature. So it still got to abide by the Constitution. The Constitution is its mother. It still got to listen and obey its mother. But it also gave birth to statutes, right? Congress gave birth to statutes, and anyone who incorporate under a statute based on what they just performed and what they did, they are obligated, they are obligor to their statute, because now they are a creature of statute, and they have to answer to Congress, right?
Yeah.
So you have to understand these things, or it won't sit well. You won't know what to do. So how you defer common law from the civil, right? So if I look at common law, right, which is an element of Constitution, it says law and equity, right? That's a constitutional question, right? So what is the common law of the people? People have the right to contract, right? It never said that people had to incorporate under a statute, right? Me and you supposed to have the freedom of contract. So how do they trap us into this legislative body? Because the United States got involved with a private banking system to do what? Distributed Federal Reserve notes.
Mm-hmm.
And by a condition of contract, you are subject to that jurisdiction. So if you don't know how to look at the common law and look at a civil action under an inferior court, the Constitution said only the states can discharge debt with gold and silver within the state. The state, right? It never said nothing about the central government. It said the state, right? So now we got to understand, what are we dealing with? Is there a conflict? If I pay with something in gold and silver, Is there a conflict? Is there a conflict between one party and another? As we look at y'all, especially y'all individuals dealing in the commercial realm, how are you supposed to deal with things accordingly with dealing with particular entities and what they're able to do if you have an unlimited right to contract and you have personal rights? This is why understanding trust law, common law trust versus a statutory trust come in. But that's for a different, I'm going to save that for the class so you guys can start understanding there's levels to understanding this information. You can go ahead, brother Israel.
All right.
Am I making sense to you guys out there? Am I making sense, Abdullah?
Yeah.
Oh, absolutely.
Yeah, you good. Substantive due process, identification of fundamental rights, right to equality. This principle prohibits discrimination based on factors like race, religion, caste, sex, or place of birth. This principle is embodied within the 5th and 14th Amendment of the U.S. Constitution. Freedom of speech and expression. This principle is the right to express ideas and opinions without government interference, retaliation, or punishment, even if the expression is considered offensive, hateful, or immoral. However, such expression must not violate rights of others, falsely defame someone. So they can't falsely defame someone. This principle is embodied within the First Amendment of the U.S. Constitution. Right to life and personal liberty. This principle refers to the right to live without arbitrary interference and the freedom to make personal choices and live one's life without undue restrictions, essentially both the right to not be killed and the right to personal autonomy within the law, often considered together as a core principle of human rights. Freedom of religion. This principle is the right to practice one's religion without government interference, as long as it does not violate public morals as a compelling government interest. This principle is embodied within the First Amendment of the U.S. Constitution. Right against exploitation. This principle protects individuals from being forced to work against their will, guaranteeing that no one can be compelled to work under exploitative conditions.
Hey, King, mute your mic, please.
So right against exploitation. This principle protects individuals from being forced to work against their will, guaranteeing that no one can be compelled to work under exploitative conditions or be subjected to degrading treatment for labor purposes. It aims to safeguard human dignity and freedom from coercion and abuse in the workplace. Right to constitutional remedies. This principle protects and enforces the fundamental rights of citizens. It allows citizens to seek relief from judiciary if the state or other entity violates their constitutional rights.
So when we talk about, I need y'all to start understanding. A lot of us get caught up in wordplay. Public and private, public and private, public and private, public and private. We talking about personal rights. The government has a set of personal rights, and individuals have personal rights. Personal rights can extend to contract. Personal rights within the contract also are personal rights. When you're dealing in trust law and you're talking about common law, breaking down, we're dealing with personal rights. So when y'all talking about public and private rights, all we're talking about is an individual personal rights and the government personal rights. They have rights as well as you do. And the people in the government is supposed to be on equal footing because the government supposed to get its inherent rights from the people. the people said, we're going to give up our collective sovereignty to pass it over to the government to protect us. Right? This is how it's supposed to work. We don't supposed to answer to government. We supposed to form elections and say we're going to buy, based on our understanding, we're going to abide by this in this particular area and part of our society that we form. We agree as a collective mind that this is what we're going to follow. And the government said, okay, y'all agree to that, pass it into legislation. This is what we're going to do. And everybody's supposed to know the law because you guys elected to say that this is what we're going to stand on. But that's not what's happening. When you understand these principles and how to look at things, things get very clear. The mysteries start to fade off. Now you don't have to worry about people saying things or giving you things that doesn't make sense. Because now when I look at contracts, I look at for errors, omissions, defects, mistakes, right? These are the things that I'm looking for. Even when I'm looking in legislation, I'm looking for errors, defects, right? Omissions and mistakes. An omission, a lot of y'all don't understand. When somebody omits something, right? So if I say I can't interfere with your personal rights, right? But I personally omit that out of a contract. Intentionally omit that so I can try to violate your personal rights. After, right, we already agreed a part of let's say we have a part of this agreement, this franchise or this organization we create. And within the policies, it says you cannot violate personal rights. But I create a contract, I'll admit that out of contract so I can violate your personal rights. And I can say, well, it's not in the contract, that's a violation. That's an omission of guilt. Because why? You should have known because you're a part of an organization that says that you can't do this. Am I making sense, Brother Israel?
Yep.
So when you understand how to look at these things and understand how all of these things, and you understand the rule of law, guess what? It takes all the stress out of this process. Now you'll start hitting them target close, or you'll be very close to hitting it if you ain't getting bullseye. Next slide, my brother.
All right. Substantive due process. When government's actions substantially interfere with fundamental rights. Direct impact on a protected right. The government action must clearly and directly affect the ability to exercise a recognized right, not just create a minor inconvenience. Significant restriction. The interference should be substantial, not just a minor limitation, and should meaningfully impede the exercise of the right. Lack of compelling government interests. The government must demonstrate a strong and necessary reason for the interference, and a less restrictive alternative may not be available. Not narrowly tailored. If the government action is overly broad or impacts more people than necessary to achieve its goal, it can be considered a substantial interference. Examples: banning all protests on a specific topic in a public space. restriction on freedom of assembly, compelling citizens to disclose their religious beliefs on government forms. That's interference with free exercise of religion. Censorship of news articles critical of the government. That's restriction on freedom of press. Prohibiting all political speech on a college campus. That's violation of freedom of speech. Arbitrary arrest without due process is violation of procedural due process rights.
All right.
So, when you understand these fundamental principles, when you understand the rule of law, this is all equity. This is all equity. What do they mean, a lack of compelling governmental interest? What are they saying? What's another word for saying that? I'm going to ask Brother Abdullah and Brother Israel. But if you had to state that and rephrase that, what is that? What would that, because I explained earlier, what would y'all say that is? A lack of compelling governmental interest.
Lack of the government's obligation of interest, like the lack of their obligation, what they're obligated to do and look for, or
I can't hear you, Brother Abdullah.
What are you saying, King? A lack of compelling government interest.
Yeah.
What's your question?
If you had to rephrase that, lack of compelling governmental interest, what could you say this? How would you rephrase that in such a way where people can, and make it more simplified, where people will really get the gist of it?
Government must demonstrate its reason for the interference and this. Would that be personal rights? Yeah, personal rights.
Yes. Personal rights, invasion of personal rights.
All right.
You see how when you understand law, how simple invasion of personal rights. Government don't have an interest in your personal or your private rights. It's off limits. You see how the words they try to use to, and just instead of making it real simple, it's personal rights. The government can't encroach upon personal rights. So, it says not narrowly tailored. The government action is overly broad or impacts more people than necessary to achieve its goal. It can be considered a substantive interference. That means that the language is vague and that they're using to overreach into personal rights. See how simple this is, family? We're talking about protection of personal rights. They use a lot of wordplay, right, to try to lead you in a direction where you cannot figure out what is really going on. I need y'all to simplify. We need to kiss this. Kiss it. Learn these principles. I guarantee it'll make your court case a lot easier. Make your appeals a lot easier. But then you can see, because what I need y'all to understand, most of these attorneys who turn into judges, they learn process. They don't know law. That's why the Supreme Court sits there, because they're looking at the law. That's a different understanding. We talking about procedurally sound. When you start arguing law and you go into the Supreme Court and you talk about rule of law, it's a whole, they got jurisdiction for that, right? You have to raise constitutional issues. The rule of law sits at the throne of the Constitution. So you must raise the rule of law, which is a part of a constitutional question, due process, which is a part of the constitutional question, in which the Supreme Court, they're the only ones can answer that constitutional question. They don't deal with statutes. Okay, that's not their jurisdiction. They deal with the constitutionality based on these legal principles. If you don't know the principles, you don't know how to unlock the key. That's why we named this due process the key to freedom. Am I making sense to everyone? Do that make sense, Brother Abdullah?
Absolutely. You want to let's fill some questions before we go on. If anybody have any questions, type your questions in. Can you see the questions? Will you be able to see the questions, Israel? I type your questions. Put your check questions in the chat. Put your questions in the chat. We can do it. Yeah, we can, and then we'll continue. Just give answer a few questions.
All right, there's a question.
All right, we got a question.
In U.S. jurisdiction, are these principles based off canonical ethics or judicial encyclopedias like the Corpus Juris Secundum?
You understand the question, King?
No. I'm trying to understand.
Read it again, Israel.
In U.S. jurisdiction, are these principles based off canonical, I guess like canon ethics?
Law.
Yeah, canon law.
Canon law.
Or judicial encyclopedias like the Corpus Juris Secundum.
So judicial canons is based on understanding how judges must hold seats and deal in ruling of law. This supersedes all of that, right? The judges got to know these principles, right, to sit in the Supreme Court. They have to know these rules, right? So when we talk about judicial canons, when we talk about conduct, right, judicial conduct, ethics and stuff like that, right? We're looking at the conduct of a judge, but really we're talking about jurors. Is how many attorneys is really jurors? Are they really jurors? So
no, I mean very few. I mean they would have to get. They would have to study to become a jurist. They would have to study beyond law school. If they just went to law school, if they just went to law school, then the answer is no. If they just went to law school, then it's no.
So he said the second part is judicial encyclopedias.
Yeah, this is study. Yeah, this is someone who has a Juris Doctorate. They're beyond what they get in law school.
So an encyclopedia. What is an encyclopedia? Break that down for him, Brother Abdullah. That's your area of more.
That's embodied in that question. Encyclopedia. Is that the corpus Corpus Juris
Secundum.
Secundum? A secondary means secondary body of law.
Mm-hmm.
That's the corpus juris secundum. Is corpus is body, juris is law, secundum is secondary. So secondary body of law. So we talking about the foundation. Jurisprudence deals with the foundational law, or looking at the legal principles. So like if you're looking at a secondary body of law, that's not foundation. Any that's secondary is not foundation. So we're talking about jurisprudence. We're talking about the foundation of law. We're not just limited. All right, let's back this up. When we're looking at legal systems, a court is not a legal system. Court is a component of a legal system. We're going to tell you, okay, there's 5 major legal systems in the world. You got a civil law legal system, a common law legal system, a mixed law legal system, mixture of common law and civil law. You have a religious law legal system and customary law legal system. Court is not a legal system. It's a component of a legal system. So we've embodied in a legal system are legal principles. Then you also have what's called a political system, i.e. it be a monarchy, a constitutional monarchy, an absolute monarchy, a republic, form of government. You're looking at it being a socialist or socialist republic, or a communist legal communist. You have a communist, socialist form of government, a communist form of government. Those are forms of government. So you have your legal systems, you have your forms of government, and then so within you have as King mentioned, the rule of law sits at the throne. It's the underpinning. So you're looking at the canon law, a canonical canon law. Embodied within canon law are, you are looking at with our legal principles. You have a canon law dealing with international law. So you have, if you're looking at canon law, looking in as far as international law, you're looking at a set of principles. So canon law would be an analogous to legal principles or guiding foundational principles dealing with international law as well. But if you're looking at the corpus juris secundum, that is the secondary body of law. That would not, the legal principles would be above that. All right. Can you give is that clear enough, King, or do you have? Can you add to that?
Yeah. So when you understanding these legal principles, right? These legal principles is set that you cannot run government or build government without principles. So the political and the so you got 2 parts of the government, right? You have the political right? Then you have the legal system itself, right? The legal system, the principles is it's like if we look at a computer, the legal system is the software, and the the legal system is the hardware. So the principles is the software that runs it, but then you build a computer, the hard parts, the functioning parts that help move everything. That is the hardware. So it's just like having gas to a car, right? It's fuel, right? The principles is the fuel. Without the principles, you can't run the car. The car would have it couldn't move forward, backwards. It couldn't do anything because it don't have the fuel to move. So when we talk about law, without understanding these principles, everything else is useless. It's useless. That's just like having a hardware to a computer, having all the stuff, the monitor, the CPU, the mouse, but you have no operating system. It's not going to work. No matter how you put it together, how you try to say work, 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 it's not because you don't have an operating system. So I'm using these analogies to inform you how important to know these principles, understand the rule of law and all the foundational principles associated with this. Because if you don't know this, you can't know law. It's an impossibility. You can study processes all you want. This process, that process, but that don't mean you know law. That means you know components of it, of certain aspects, but you don't know law. You're still missing certain important ingredients to make sure this stuff works and operates. You get what I'm saying? Do
Mm-hmm.
that make sense? Do that make a lot of sense?
Yeah, absolutely. Let's go to another question.
All right. Someone says, so King, if it doesn't say it in the contract expressly, you aren't protected. I guess, are you not protected? If it doesn't say it in the contract expressly, are you not protected?
Well, there are certain guarantees that's by the Constitution, right? There are certain understandings that the court must look at. So something not being expressed doesn't mean that you're not protected under it. You just have to understand what you're looking for. Because if you don't know what your rights is, the court is not there to help you identify what your rights are. They're just here to look at a dispute. And whatever argument that you raise is the argument you live and die by. So what you need to do if you do deal in contracts, you need to express it as much as possible. You need to write as much as possible to ensure the integrity, or you need to have what I call a catch-all clause or catch-all provision, right? That may catch any other issues, right? That then say, well, this is the catch-all provision to ensure that if any errors, omissions, and defects in this contract associated with the severability clause, that we then refer to the policies and procedures that's also right, or we extend to, or we look for guidance from the trust protector to ensure to protect the rights. Whatever the language that you want to put in there, right? So that you can help understand that you got to catch up for it. You can understand what I'm saying? So You need to understand how to think about everything so that you can ensure how to move. Because if you don't know this, you don't understand. This is why we're teaching a course about legal safeguard, contractual trust, and contractual legal safeguards. Why do you want to safeguard? To make sure that if you mess up or something go wrong, that you're protected behind the substantive language in the contract. And that the court cannot say, oh, okay, we're going to take that right away. No, they can't, especially if it's not encroaching government rights or property. I don't just look up, family. I do this because I understand law. I can explain this back in my sleep.
Can you want to take another question? Another question.
I think that was a
That's it. No more at this time.
Yeah.
All right, go ahead, King. We continue.
Go to the next slide.
Substantive due process, judicial reviews. Marbury versus Medicine, 5 U.S. 137, 1803. Primary holding in the case. Congress does not have the power to pass laws that override the Constitution, such as by expanding the scope of the Supreme Court's original jurisdiction. Fundamental rights identification. The first step is to determine if the law in question impacts a right considered fundamental under the Constitution, such as the right to privacy, marriage, or free speech. Level of scrutiny. Depending on whether a fundamental right is implicated, the court will apply either strict scrutiny for fundamental rights or rational basis review for non-fundamental rights. Strict scrutiny. Under strict scrutiny, the government must demonstrate that the law is necessary to achieve a compelling government interest and is the least restrictive means to do so. Rational basis review. Under rational basis review, the government only needs to show that the law is rationally related to a legitimate government interest.
So we got to understand the rule of law when we're talking about all of this, because we're dealing with personal rights. Once again, fundamental rights identified. What is fundamental rights? Personal rights. What is personal rights? These are inherent rights, right, that every man and woman and child possess. These are rights that government did not create. These are rights that is well known under the philosophy of law, dealing with jurisprudence, under the principle that every man, woman, and child. So we also talk about human rights also, right? Right to having a nationality. That's a human right. So anybody who's claiming black and you denationalize yourself, right, by your own intention. I'm black. Even though we already know this, they subjugating us. That is a human rights violation. When they stripped us and made us identify as black, that was a human rights violation under the international scope. That's genocide. Slavery is not language, substantive language in international law. Slavery is just a word, a coined phrase that they utilize us to trick us from understanding internationally what they're doing to us. So when we're looking at personal rights, we're talking about this is why the strict scrutiny rule come in when we talk about strict scrutiny, right? Why is the government saying that it has to be strictly construed? Why? Because they have to dance on eggshell to see if they're dancing upon a what? Personal right. I want y'all to make this simple. Fundamental rights is dealing with personal rights, rights that's inherently in every man and woman. And government must be strict when looking at legislation by an inferior court. They can scrutinize that strict. Why? They have to be strict because if that statute violates a personal right, inherent right that you have personally, that every man and woman and child possess, then that statute is void ab initio. And now you can challenge the constitutionality of the construction and the substantive language in the statute. I don't even, because if the statute itself evades due process, because it's stripping you of a personal right, the charge that they're charging you with, they can't even charge you with because it's constitutionally unsound. That means it didn't meet constitutional muster, and now you can ask them to remove this charge based on dismiss this case because it evades every process of constitutional muster and that it evades due process. I hope I'm getting through to y'all. I can fight from every angle. I can look at the statute and say, well, this statute is not don't meet constitutional muster. This is a violation. It's thin. What you're doing is the state is the possession of a statute that violates every woman and man and child rights. You can sue the state under a permanent injunction and say that statute is violated. Everybody who ever been charged under that need to be released. You can permanently suppress that statute. You can sue, right? And show that that statute needs to be repealed or removed. When you understand how law operates. But if you don't understand these principles, I don't care how many processes you think you learn. You don't know law. You can never be a jurist. Am I making sense to you guys tonight?
Yeah.
Yes. Do we have a question? Is Israel?
Let me see.
You see a question?
Somebody said,
Yes.
can I say something to the group about contracts in the comments? It's private information. I guess that's why I'm asking first. That's really
Read that again, please.
Can I say something to the group about contracts in the comments? It's private information. I guess that's why I'm asking first.
King, what say you?
He want to, I don't know, I guess he want to say something to the group.
So he said, so you want, he's okay. So yes, he said yes. All right. So type it in, brother or sister.
As long as it's not a misconception.
Well, we're going to address that too.
Right.
Yeah, type it in. Type your question in. Well, we want to. That's good. Well, we'll continue, King, until the question's typed in.
So I want everybody to understand, right? When we're talking about nationality, right? Yeah, and I ain't gonna lie, I love this brother. When I see you, I'm gonna give you the biggest hugs, bro. Like you taught me so much in short of period because you know this information backwards and forwards, right? It was very important to know this information because we are being enslaved. We think that the Constitution, we had something to do with it. That's a subjugating instrument. That's a colonizing instrument. That instrument is suppressing us. We can't use that instrument for our freedom. We got to look to international law. It's beyond the scope of the United States. Our sovereignty wasn't granted by the United States. So it don't depend on the answer of the United States for our sovereignty. When you understand international law, when you understand these principles, and you understand all the things, being our doula, we talk all the time, and we really understand this information, and when you really understand it from a domestic and international perspective, you will start to see the answers of all of these questions just unfold. We have a sovereignty that predates the United States. It pre-existed. So how could something that pre-exists an entity rely on that entity to grant back its sovereignty? It was before you. And that's not in the international law principle anyway. The granting of sovereignty to another nation. That's not a principle. You can't be a nation within a nation unless you're a subjugated state or subjugated nation. So when we understand this, right, we can then start to look at these mysteries and break it down. It's just a lot of people they don't understand law. So they have a hard time winning cases. And I'm telling you, I look at people and I see the stuff that they submit. I be like, what made you do that? What was your logic? And a lot of it is coming from we're parenting other people that we consider gurus and their information, and it's incorrect. Brother Israel, everything that I talk about, you researched, didn't you? You researched it.
Yep. Everything.
You can pull up. I didn't. It wasn't me. I didn't. And then King El Bey said it predates me. I had nothing to do with this.
I was able to put this whole PowerPoint together on my own, just because you showed me how to think about things, how to look at it. Show me what to look for.
So this ain't something that King El Bey made up. This predates me, pre-exists me a long time ago.
Mm-hmm.
You see what I'm saying? The ancient ones created some of this stuff. They created this stuff, this legal system and all the equity and all of these different things. And then our colonizers pick and choose what they pick from the fruit of justice. They picked and choose what they wanted and restructured it so they can keep you suppressed. Right? So they can always have a controlling interest. Right?
Yep.
We got the controlling interest. 50, all they got to do is win 51% to your 49. They always got the controlling interest. So what they say, rule. No, that's not how it's supposed to be. That's only because they made us believe certain concepts because we don't look toward international law and they don't teach it. So what me and Brother Abdullah, we resurrecting the dead. We teaching something that our ancestors taught us, right? And now we bringing it back to the community to teach you proper concepts, to have proper knowledge, proper way of thinking, looking at law.
Yeah.
Because most of the time what you're hearing is this process. I'm going to teach you administrative process. What is that? What you mean administrative process? Are you administrative agency? Oh, you a creature of statute, right? And you created an administrative agency under that statute? Is that what you did? I don't know what you performing, my brothers and sisters. Because all I know is that we have private rights of action. Look it up. You can look that up. Private rights of action. Private rights. What is private rights? Personal right. So people gonna always, man, this public and private. Man, come on, man, it's this personal right. To government can't infringe upon personal rights that government didn't create. They don't. So just like they don't post, they didn't give life. They're not supposed to take life, but they take life. That's violation of a personal right. All of this stuff is equity, right? The election of the people working as a collective, right? People electing. That's why you have state elections. This is why you have the electoral college. These people are your elected officials that you said you want to represent you in your interest. If you understand, they just give us bits and pieces, but we gonna put it pop together. Is there another slide, brother?
Yeah, last slide for the substantive due process. Substantive due process, controversial applications, moral dilemmas, many controversial legal applications involve deeply held moral beliefs, leading to strong opinions on both sides of the issue. Interpretation of laws. Different interpretations of existing laws or the creation of new legislation can be led to controversy, particularly when dealing with the emerging technologies or social issues. Impact on individual rights. Controversial applications often raise questions about the balance between individual freedoms and social needs. Examples: reproductive rights, debates surrounding abortion access, including restrictions on late-term abortions, parental notification laws, and access to contraception. Euthanasia and assisted suicide. Legalization of assisted suicide for terminally ill patients, raising ethical questions about the role of medical professionals. Criminal justice reforms. Issues like mandatory minimum sentencing, 3 strikes laws, and the death penalty, with discussions around fairness and disproportionate impact on certain demographics. Freedom of speech. Balancing free speech rights with restrictions on hate speech, defamation, and online content moderation. Surveillance technologies. Government surveillance programs, including data collection practices and privacy concerns related to technology advancement. Affirmative action. Policies designed to promote equal opportunity for historically marginalized groups, often debated regarding potential for reverse discrimination. And gun control. Debates regarding restrictions on gun ownership, including background checks, assault weapon bans, and concealed carry laws.
So if you look deeply into this, right, in the moral fabric of things, this is really dealing with our personal rights. The government, anything that the government creates and a government contract with another private individual and they have a vested interest, they have some control, they have some say. And if you attach yourself to governmental property, then they have a right to tell you how to use their property. It's really simple, right?
Yep.
Government can't encroach upon you, you can't encroach upon government. So if you're accepting benefits and privileges, right, from government in the sense of using their property to benefit, they have a right to tell you how to utilize it. And then they can say you got to pay for it through taxes. They say, well, based on you having this governmental property, there's taxes associated with it. Right?
Yep.
So when you create something, right, you have a right to, but the government say, now we're going to limit this to authors exclusive rights. You only get it for a limited time. Why do government do that? So that someone couldn't constantly, right, overcharge. So let's say if I was the inventor of shoes, gym shoes, right? Nobody can ever create gym shoes. And I could go up 1,000% because I own the patent and all the rights to it. So I can always sue whoever tried to make a shoe. And I can hold and maintain all property rights to that shoe forever and forever. Right? So the government say, now we got to prevent that. Why? So that people can't abuse that. Right? So when you look at a lot of this, we got to understand, break it down to personal rights, encroachment of government personal rights, because the government has contracts with private parties all the time. And you got to understand these private individuals that's in bed with government. So this is it, brother.
We have
substantive due process. Yeah. So
yeah. This is it regarding the due process. We have go to the. You have the other stuff up there, right, Israel?
yeah.
All right.
So title, philosophy of law is incorporated in every aspect of a legal system, which stabilizes the legal procedures. Author, Keng El Bey, committee chair of the Moorish Investigative and Research Committee. For free recorded lessons, go to the Moroccan Post Media on YouTube. Without understanding the philosophy of law, one will never understand the jurisprudence. The people are the architect of government and must be given the proper tools to build and run government. The people are the source of government power. The ultimate source of all government power is the people.
All right, stop there. Ken, you want to elaborate?
So what we got to understand is, right, remember this. So based on when we were stripped, we had a certain culture, we had a certain language, we identified with each other a certain way, and we presented certain things. So this is based on your philosophy, culture, and everything. You build government based on that. So the people, right, they say, okay, we're going to say if this is an Islamic court, these are Islamic people, they would elect to have an Islamic tribunals, right? A religious body, a religious court, based on these principles of the Quran, right? And they would take these principles, these fundamental principles, and incorporate into their everyday living. This is what I mean by the people being the architect. The government did not build itself. The people built government based on their ideals, their philosophy, and culture and traditions. Based on that, they took and they said, okay, this is what the government is, a reflection of the people. So when government don't reflect the people who they supposed to very protect, then it's something different.
Next slide.
The exercise of government power. Anyone who exercises the people's power must be structurally accountable to the people. Note, accountability is an element of the rule of law. The rule of law and constitutional governance. The legal principles, the building block of a constitution. Legal principles, the building block of a legal system. Legal principles as the DNA of a legal system, preparing the Moors for self-determination and self-government.
You want to elaborate on this slide, King? Are you?
Yeah. So legal principles is, like I said, it's the ultimate ingredient for building government, building a constitution, building a legal system. Without the principles, I told you, it's like having a car with no gas. It's not gonna go nowhere. It's like only having a computer with a computer hardware with no CP, with no operating system. It's not gonna operate. This is how important these principles is. And anybody who's not teaching from the principles, they're not teaching you law. What they're doing is they teaching you segments or aspects of law, but they're not teaching you law. Because this is the foundation. When you build a house, you start with the foundation. You don't start with the roof.
All right. Next slide.
Legal principles set the foundation for a just and transparent legal system, ensure the proper functioning of government institutions, and uphold the consistent application of law. Legal principles serve as the foundations underpinning a legal system. So legal principles serve as the foundation underpinning a legal system and guide judicial decision making. Understanding these concepts is vital to fully grasp the intricacies of the law. A constitution outlines the fundamental principles, institutions, and functions of nation state and provides the legal framework for the entire legal system.
Let's go to the next slide.
The rule of law governs how the law works. The rule of law tells how law is supposed to operate. It is the guiding light to law. How the application of law works. The rule of law is the guidance principle in a common law legal system and civil law legal system. The judge uses the rule of law to help them make a determination. An individual can measure the accuracy of the court using the findings of fact based on the rule of law.
So, yeah, so when you understand this, right? When you really understand this will change your ability to analyze cases. This is really it right here, right? You got to learn these principles because these principles are very essential to your developmental understanding of law and its operation. You can go to the next slide, brother.
You can look at a case to see if the elements of the rule of law exist. Determining the elements in the facts will allow one to see what legal principle applies. Recognizing cited facts and principles in legal judgments, extracting legal principles from cases. Cited facts in cases can be used to illustrate the legal principles that are supported by the cited case and material facts that are necessary for the principles to be invoked. Analysis of legal principles and facts within cited cases allows identifying the key information about the cited case. The associated legal principles and facts of a case provide deep access to and insight into the development of the application of law. Applying law to facts, determining the legal consequences of a set of facts. In other words, determining what the governing rule of law requires of parties when those facts exist. Go ahead.
So remember, I want you to think about legal principles like this. Legal principles have certain elements. Those elements are those elements are like fingerprints. that identify that legal principle. Once you understand the context of what you're doing, based on understanding these principles, and that you understand how to identify the elements of each principle, you can now solve a lot of riddles if the court applied the proper principle with the proper case. Or you can challenge that based on the rule of law and due process because you know the principles and under the proper application. This is how we was able to look at Michael Long Bay case, and he came out with a victory because he understood certain things. We can go to the next slide.
Application of law. It involves interpreting and applying statutes, regulations, and legal precedents to the facts of a case to reach a legal conclusion or judgment. How the court ruled on a case. These facts do not align with the rule of law. How to win cases. How to look at due process. Legal system versus tyranny. Equity, equality. The people give the government her power.
Right. So, yeah, you can keep going because a lot of this stuff we kind of went over in certain aspects.
So, application of law as a legal principle, the process of determining the legal consequences of a set of facts, what the law requires of parties when those facts exist, and how a law is applied to a case. Moorish Investigative and Research Committee. For free recorded lessons, go to the Moroccan Post Media YouTube.
Yeah.
Conclusion of law as a legal principle. An answer to a question of law is as applied to the specific facts of a case. A decision made by a judge about how the law applies to a particular case. It determines what laws are relevant and what laws are not relevant.
Right.
Source of law as a legal principle. Intent and purpose of the statute. Legislative history. Legislative minutes. General Assembly that ruled and adopted the statute. This is the next one. So title. National pride is rooted in the knowledge of a people's nationality, cultural identity, ancestry, and history. Author, Keng El Bey, chair of the Moorish Investigative and Research Committee. For free recorded lessons, go to the Moroccan Post Media YouTube page. The universal principle of a people's national pride is rooted in their knowledge of their nationality, cultural identity, ancestry, and history. The 1684 Francois Bonner's new division of the earth race paradigm of using words having no connection to a people's nationality, ancestry, consanguinity, genealogy, descent, national origin, pedigree, parentage, lineage, history, national sovereignty, national constitution, treaty protections, culture, blood right claims to land, birthright, heritage, geography, has stunted our growth to expand our minds to studies in the areas of nationality and its connections to sovereignty, rule of law, legal principles, and constitutional self-governance and self-determination, giving our people legal remedies based on our pre-existing Moorish sovereignty and not based on fictions and law. The universal principles. Oh shoot, that's the same thing. Oh yeah, so that's that. Yeah, so that sums it up for that. Moorish Investigative and Research Committee educational lessons on the Moroccan Post Media YouTube page. Free recorded lessons. Moroccan Post School of Government and International Law by Terrence Bey, Sheikh Malachi Bey, and Abdullah El Talib Mosey Bey. Moorish Union of Sovereign Tribes by Brother Keng El Bey. Session 1, the basics of criminal investigation, the meaning of evidence, finding of facts, and conclusion of law. Session 2, Introduction of the Application of Law and Evidentiary Standards, Part 1. Session 3. Introduction to the Application of Law and Evidentiary Standards, Part 2. Session 4. Using Legal Principles to Draft Motions and Pleadings, Part 1. Session 5. Jurisprudence/philosophy of law and legal principles as the foundation to run government and to handle legal cases. Session 6. Using legal principles to draft motions and pleadings, Part 2. Session 7. The use of affidavits, notary processes, and notary presentments.
So once again, you can go to the Moroccan Post Media YouTube page for these free recorded lessons. That's the Moroccan Post Media YouTube page.
So this book by Keng El Bey and Brother Abdullah El Talib Mosey Bey, called The DNA of the Legal System.
Upcoming summer, we're probably looking at the fall of 2025.
All right. Trust and contractual legal safeguards. This 12-week course provides an in-depth exploration of trust, contracts, and the legal mechanisms that safeguard them. Our course, Master Trust Functions, discover the role of a trust protector, intellectual property law, demystify assigners and assignees, understand power of attorney, navigate licensing, leasing, and renting, strengthen your contracts. Duration 12-week. It's a 12-week course. Starting date Saturday, March 8th, 2025, and it'll last from 2 p.m. to 5 p.m. Eastern Standard Time. Format 100% online with live question and answer sessions. Tuition $299 notes and 99 cents. Register now. For more information, you can contact Brother Abdullah El Talib Mosey Bey at 215-300-5471 or on email at etymologyvocabulary@gmail.com. So, trust and contracts, legal safeguards. Teacher, Keng El Bey, coming March 8th, 2025. Duration, 12-week schedule. The course outline and overview. This 12-week course provides an in-depth exploration of trusts, contracts, and the legal mechanisms that safeguard them. Each week builds upon the last, offering a comprehensive understanding to help you navigate and apply these concepts effectively in both personal and professional contexts. Week 1, Introduction to Trusts. Students will learn the fundamentals of trust, including definitions, purposes, and the roles of the settlor, trustee, and beneficiary. This foundational week sets the stage by discussing the legal basis and common uses of trust in estate planning and asset protection. Week 2, Types of trusts and their functions. This week explores different types of trusts, such as revocable, irrevocable, living, testamentary, and special needs trusts. Students will understand how each type functions and the responsibilities involved in managing trust assets. Week 3, Benefits and limitations of trusts. Students will examine the advantages of using trusts, including asset protection, tax considerations, and estate planning benefits. The week also covers the limitations and risks associated with trusts and strategies to mitigate them. Week 4, The role of a trust protector. This week introduces the concepts of a trust protector and their importance in trust administration. Students will learn about their duties, powers, and how they can modify trust terms, oversee trustees, and resolve disputes. Week 5, Assigners and assignees in contracts. Students will understand the process of assignment in contracts, the legal implications, and the responsibilities of assigners and assignees. The focus is on how rights and obligations are transferred within contractual agreements. Week 6, Licensing and Rights of Publicity, Part 1. This week delves into licensing with a focus on the right of publicity, exploring how individuals can control and monetize their image, voice, signature, and other personal attributes. Students will learn about the legal basis of the right of publicity and how to create licensing agreements for personal rights. Week 7, Licensing and Rights of Publicity, Part 2. Continuing from week 6, students will learn about protecting and enforcing the right of publicity, including unauthorized use and legal remedies. The week also covers leasing personal rights, considerations in the digital age, and ethical implications. Week 6, Power of Attorney, POA, forms and uses.
Are you week 8?
Yeah, week 8. Students are introduced to the concept of power of attorney in its various forms, including general, special, durable, and medical POAs. The week emphasizes the importance and practical applications of granting POA in financial management and healthcare decisions. Week 9, Legal considerations of power of attorney. Building on the previous week, students will learn about execution requirements, revocation, termination, and safeguards against abuse of POA. The focus is on legal aspects to ensure the principal's interests are protected. Week 10, Contracts and Safeguard Provisions, Part 1. Students will explore the essentials of a valid contract, including offer, acceptance, consideration, capacity, and legality. The week also covers common safeguard provisions like indemnification clauses and limitation of liability. Week 11, Contracts and Safeguard Provisions, Part 2. Continuing contract studies. Students will learn about confidentiality agreements, termination clauses, and dispute resolution mechanisms. The focus is on drafting effective contracts with robust safeguard provisions to mitigate risks. Week 12, Constitutional Studies with course review and question and answer session. In the final week, students will spend the first hour on constitutional studies, exploring how a national constitution is a national trust. This will provide a broader legal context and understanding of the foundational laws governing these areas. The remainder of this session is dedicated to reviewing all the concepts learned throughout the course. An interactive question and answer session will allow students to clarify any doubts and discuss practical applications. First hour, Constitutional Studies. How a national constitution is a national trust. The overview of jurisprudence/philosophy of law, legal principles as the foundation to run government. Rule of law and constitutional governments. Rule of law, constitutional governance, and the protection of fundamental rights, individual rights, and civil liberties. Constitutional clauses affecting contractual obligations. Case studies illustrating constitutional influence on trust and contract law course review and Q&A session. Comprehensive review of course material, recap of key topics from weeks 1 through 11, interactive Q&A session, addressing student questions and clarifications, discussing sharing insights, experiences, and practical applications course, and practical applications. Course evaluation, providing feedback on the course experience. Yeah, that's the last. That's it.
All right. Thank you, Brother Israel. You did a wonderful job, man, putting this together. And with your assistance, Brother King, wonderful job. You knocked it out the park as usual. Next week I have Brother Khalil. He's going to be doing the. He was scheduled, and so we're bringing him back to actually. We had technical difficulty, I think, about 3 weeks ago. It's called Masonic Astronomy. Esoteric Masonry. Esoteric Masonry, Brother Khalil next week. And then we have Brother El Kanan. The fourth, he'll be doing every fourth Monday of the month, Brother El Kanan Bey. But next month, the fourth Monday will be Brother Cosmo Il, Grand Sheik of Moorish Science Temple. Forget what temple number. Brother Cosmo Il. He'll be in New York that week, and he'll be on my Moorish Monday on February 24th, Monday, February 24th, which is the fourth Monday of February. And then Brother El Kanan Bey will take the third Monday for next month. I think Israel and I will be doing the second Monday in February, and then I have Crip Jesus. Crip Jesus will be doing the first February 3rd. February 3rd, I have Crip Jesus. He's a Moorish Science Temple out in California. Mother Crip Jesus. He'll be February 3rd. February 10th will be Israel and I will be doing February 10th. I have March 17th. March 6th will be Luisa Flores. Luisa Flores, she was a keynote speaker of the May 18th Political Unity Conference. March 3rd, Monday, March 3rd, Luisa Flores. I have Monday, March 17th. I have Brother Dr. Powerton, Grandmaster. Dr. Powerton will be doing. He will be a reader's review and Master Mason of my book, Masonic Compass Square and the Connection and Measurement of Timekeeping. That is Monday, March 3rd, March 17th, Brother Dr. Cosmo Il, Master Mason, and he will be doing this again. So March 10th, I can't recall who I have for March 10th. And so I'll be continuing to scheduling people. Thank you very again, Brother Hank, for this platform. Till next week. Peace, everyone.
Peace.